Elements in the gun case against a Louisiana-based rapper who was arrested in San Diego last year. Today, a San Diego judge threw out the felony firearm possession charge against 41-year-old Torrance Boosie Hatch Jr. Hatch, who's been convicted on drug charges in the past, was arrested in Choias View last May during a traffic stop after authorities say they found 2 loaded handguns in his vehicle. His legal team asked a judge to drop the charges, citing a ruling by a California judge in another case that found stripping a nonviolent felon of their right to own a gun was unconstitutional. Ultimately, the judge today agreed and granted Hatch's motion to dismiss.
What's up, everybody? This is Mr. 100K a day, and today we're going to be talking about Lil Boosie. He got his gun case dismissed, his federal gun case. He got caught out in San Diego with a firearm. If you guys remember the incident that happened last year, he was on a rap video. The police were, and the FBI federal task force were watching a particular rapper, a guy he was working with. Boosie, of course, everybody know he's a convicted felon, was seen with a firearm in his waistband or his in the small of his back out in California, and they saw him on Instagram Live, and they came and jumped down on him. So he made a big scene about it. So it was a state court case at first, then it was transferred to federal court. So he was able to beat his case. A lot of people have been reaching out to me about these particular cases that have been coming out dealing with the firearms charges based on the Supreme Court, a Trump mostly appointed Supreme Court panel. And a lot of these cases have been very favorable to defendants, and they've been favorable to defendants because what they've been doing is engaging in what I call these are constitutionalists mostly, and they're purists. What they do is they go back and analyze the Supreme Court. I mean, they go back and analyze the Constitution and analyze things as the way it was originally intended. So Congress, of course, has enacted a lot of laws, a lot of situations, a lot of things have developed since the Constitution was originally implemented. And now they've gone back and understand and saying, hey, this is the Congress, the Supreme Court didn't intend for, I'm sorry, the writers of the Constitution didn't intend for this, for people to have these things, rights like this, stripped from them. So the case that got Boosie's case dismissed was a case out of the California, which out of the Ninth Circuit, which a lot of people got to be aware of. The United States is broken into like 12, 13 circuits. California falls under the Ninth Circuit, very liberal. They if you have something coming towards you, usually they give it to you, meaning your rights have been violated or anything, or if you have a constitutional issue, usually they are very, very favorable towards defendants whose rights were particularly violated. Now, this is an appellate case, and it can still be appealed all the way to Supreme Court. So this still may eventually be overturned. But for now, in the Ninth Circuit, this is what the law is. So the thing is, and this is not to make it too long, this is the ruling on the case that Lil Boosie used. So what they went and did was they went and analyzed how the Second Amendment was originally done and how throughout the United States history, the United States had a history of disarming people that they found to be unfavorable. Of course, slaves, Catholics, and things like that. So they did a very, very comprehensive analysis. For example, here they said laws disarming Catholics fare arguably worse as historical analogs to 922G1. 922G1, guys, for the sake of clarity, is the federal statute that makes it a crime to possess firearms for certain classes of people. Felons are in there. People who've been convicted of domestic violence are in there. If you had a restraining order on you, that's in there. If you're an illegal alien, that's in there too. So they go into detail, say, because the government points to only 3 such restrictions. In 1756, Pennsylvania and Maryland's colonies each enacted militia laws that seized arms belonging to any papist or reputed papist and barred them from enlisting in the local militia. So they right here says the Virginia colony that same year required any person suspected to be a papist to swear allegiance to the Hanoverian dynasty and to be Protestant into the Protestant succession. No Catholic so refusing could have any arms, weapons, gunpowder, or ammunition. So the United States had a history really of disarming uh you know Catholics, black slaves, natives. That was really the history. So they really went into a lot of detail. Like even right here, they talk about the laws disarming Indians. Is it like Catholics and loyalists? Indians, while not traitors, have always been considered members of a distinct, independent political community with whom the colonies were frequently at war. Indians, simply put, were not citizens of the British colonies and were not entitled to the same rights as of English subjects, so they could be disarmed as a matter of course. So it says, for example, in 1675 Virginia law, after condemning the sundry murders, rapines, and many uh, depredations, depressions. I'm sorry, I'm sorry, y'all, for that. Lately committed and done by Indians on the inhabitants of this country, resolved that a war be declared against all such Indians and warn any person within his colony presumed to trade with any Indian, any powder, shot, or arm shall suffer death without benefit of clergy. New York and Massachusetts similarly denounced the dangerous practice of selling guns to Indians as causing the destruction of the Christians and as a very poisonous and as very poisonous and destructive to the English. So they really went into a lot of detail in this particular case is how they disarm people. And this one was extremely important. And this is, they talk about the laws disarming slaves and free blacks. The now familiar reasons for disarming loyalists, Catholics, and Indians also motivated laws disarming slaves and free blacks as a class. Slaves, by definition, fell outside the people entitled to Second Amendment protection. And free blacks, like the Tories and Roman Catholics, were considered non-citizens or at best second-class citizens. At the time, they enjoy only rights. They enjoy any right to arms solely as a matter of legislative grace. And they quoted this case, State versus Newsom out of North Carolina, concluding that free people of color cannot be considered as citizens in the largest sense of the term, and the state therefore has the power to say who this class of persons shall have the right to license and keep arms as to whether they shall. The external danger of Indian attack, moreover, was consistently matched by the equivalent fear, especially in the South, of indentured servants and slaves as a class. They talk about it extensively here. But the overwhelming thing is that as with every historical analog the government relies on, laws disarming blacks still allow for certain case-specific exceptions. Virtually every law that we found contained exceptions for exemptions for slaves who were armed but had in their possession a ticket or license from his or her master. This was basically a certificate authorizing them to possess firearms for some limited purpose, usually to hunt or kill game. To be clear, the notion that blacks as a class were equally entitled to the right to possess arms for self-defense arguably did not enter the public conscience until Reconstruction. But what these and other exemptions demonstrate is that categorical bans on certain groups possessing arms gave way when justifications for disarmament no longer existed. The slave carrying the master's arms to and from this plantation did not pose the same threat under the law as a slave who carried a gun after sundown. So they really, really went into a very, 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 very deep historical analysis of what this the United States has done to disarm certain groups of people. And to sum it up, it said 922 G1, which is the statute, the federal statute, has no analogous exceptions for the class it targets and thus bears little resemblance to the class-based firearm prohibitions in effect at or near the time of the Second Amendment was ratified. So this is the case that got Lil Boosie got his thing dismissed, because the guy who was in this case ultimately he won it. And I believe this case is right now being appealed to the United States Supreme Court. So what I believe worked for Lil Boosie is, it's a great thing. He was able to beat his gun charge. He was able to avoid going to prison for, I'm sure he would have been in prison for at least 2 to maybe 7 or 8 years, depends on how significant, how aggravated they would have found his criminal history to be. And we all know Lil Boosie had murder charges back in the day that he was found now guilty of. And in federal court, they have a tendency to not just look at the crime in which you're currently being charged with, but they also have a tendency to charge you, or let me say sentence you, based upon what they call relevant conduct, or what they call 3553 factors, which are factors that they say go into the nature and the characteristics of the individual being sentenced. So they could have easily given Boosie the statutory maximum if they wanted to, which would have been 10 years, based upon what they could have called a repeated tendency to engage in criminal activity, even as a convicted felon. So he beat the case, though. But the problem for a lot of people is that, that was the Ninth Circuit, which includes California, Arizona, Oregon, I believe Washington, just a few states, and maybe Nevada is thrown in there too. So a lot of people who I'm in contact with, and a lot of people who I work with, are out of another circuit, and that is the Eighth Circuit, which also is one of the most conservative circuits in the country. And when I say conservative, it's not conservative like in the sense that the Supreme Court currently is. They're conservative in the way of they really don't want to give you anything. If you ain't got it coming, it's not laid out, they will fight it all the way tooth and nail, all the way to the Supreme Court, to make sure you don't get what you think you're supposed to have coming. So this is the case that came out last year from the Eighth Circuit, which includes Missouri, Arkansas, Nebraska, Iowa, Minnesota, North Dakota, South Dakota, and I believe that is it, if I'm not mistaken. So the Eighth Circuit is extremely conservative, and this guy argued the exact same thing. So I'm gonna skim down to the analysis where he argued the same thing and said it was unconstitutional. Right here, it says that clear as day. He was arguing it was unconstitutional for 922G applied to him, saying that because his drug offenses were nonviolent, do not show that he was more dangerous than a typical law-abiding citizen. So this is the exact same argument Lil Boosie had. This guy gets shot down and stays in prison, and Lil Boosie beats his case out of the Ninth Circuit and doesn't even go to prison. So this is just to demonstrate just how different, based solely upon the jurisdiction in which you catch your gun case, is just how different the results can be. One guy goes and stays in prison, one guy doesn't even go to prison, and that is a major, major, major difference. So you got to always be aware of what you're doing or what your loved ones are involved with, depending on what jurisdiction you're in, because it can literally make the difference between them going to prison for a very long time, sometimes even life, or them not going to prison at all. So just to do a quick summary of what they ruled, this is the Eighth Circuit. When they ruled this, they said, we conclude the district court was correct that 922G is not unconstitutional as applied to Jackson based on his particular felony convictions. The Supreme Court has said that nothing in the district, this is a Supreme Court case, District of Columbia versus Heller, which recognizes the individual right to keep and bear arms, should be taken as to cast doubt on long-standing prohibitions on the possession of firearms by felons. So they basically shot him down. Okay, so they went back and talked about colonial America, about the legislators and prohibiting Native Americans from owning firearms. They did the exact same analysis that the Ninth Circuit did in California and came to a completely different conclusion. So I believe this case, these gun cases, ultimately, like I said, is going to end up in the Supreme Court. They're going to have to make a ruling on it. They just ruled on a very a related issue with, as far as a guy who had a restraining order against him and had a firearm, and he lost to the Supreme Court just a few weeks ago. He lost because the Supreme Court made a determination that there was a specific level of dangerousness that that man had been found to possess before he was stripped of his firearm, his Second Amendment rights to possess a firearm. So to sum it up, this is what it said. In sum, we conclude that legislatures traditionally employ status-based restrictions to disqualify categories of persons from possessing firearms, whether those actions are best characterized as restrictions on persons who deviated from legal norms or persons who presented an unacceptable risk of dangerousness. Congress acted within historical tradition when it enacted 922G1 and the prohibition on possession of firearms by felons, consistent with the Supreme Court's assurances that recent decisions on the Second Amendment casts no doubt on the constitutionality of laws prohibiting the possession of firearms by felons, we conclude that the statute is constitutional as applied to Jackson. So that's how it worked for him. Like I said, exact same situation Lil Boosie was in, but two completely different results, predicated solely upon the fact that one caught their case in the Ninth Circuit, one caught their case in the Eighth Circuit. The Eighth Circuit is extremely unfavorable. And this is going to be a situation, like I said many times, it's going to have to be taken up by the Supreme Court. And they're going to have to ultimately make a decision as to who's right and who's wrong. So, you know, I'm happy Lil Boosie beat his case. Hopefully he can stay out of trouble. This case that I just showed you was out of Minnesota, which, like I said, is out of still the Eighth Circuit. But I think is extremely telling about how, like I always say, you can easily find yourself in deep crap or get yourself out of deep crap just by where you catch your case or simple wording of the law and about who's interpreting the law is very, 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 very fact and detail specific. And hopefully you have a lawyer or paralegal on your side who's going to read the fine print and fight for you, because at least, you know, you don't know what results you're going to get until you at least fight for it. So anyway, this has been a nice one right here. And I want to get your, you know, hopefully you guys get a little information. I want to get your feedback on it. A lot of men, especially black men, are in jail of firearms and firearms possession. And this is a very easy weapon that's, no pun intended, but this is a very easy law that they use against black men to put them in prison. A very easy law, because they know black men, a lot of time we got to protect ourselves from each other and from other things, especially if you're from the inner city. And we got several levels of danger out there that some other groups do not have to the same extent in the United States. So they easily put the guns on you. They can easily lie and find a way to search for a gun in your car, your house. It's so many different ways they have to try to wrap black men up in this. And I think it's very important that you have at least a basic ability to understand what type of situation you're in and how you can fight your way out of it. So I hope you guys enjoyed this with 100K Paralegal Services. And till next time, take care. Peace.